Let's go to Ann in Mount Dora. Ann, you're on News Talk WDBO. Go ahead.
My question is, I had a tenant here. We had a month-to-month agreement, and they didn't pay their first month's rent, so we gave them an intention to vacate the premises. And before we could serve them with eviction papers, they moved out and they left some things in the property, didn't pay their rent, and we don't have a forwarding address, so I have no way of contacting them to tell them to take the things out or to file proceedings to recoup my rent. What do I do about that?
All right, Ann, I want to ask you, too, do you have a security deposit? Do you have any money that they gave you?
They gave half of the security deposit.
And so how much money do you have, Ann?
$250.
And so that check is cleared. You have $250 in your hands.
Yes.
So, Rob, here's the issue, and that is the tenants, before they began the lease, they have moved out. Ann does not know where these tenants have gone to. She has $250 of their money, and the tenants have left behind some personal property in Ann's house. Those are two separate issues, but what should Ann do?
Okay, well, there are at least two issues, and let's start with the easier of the ones, which is I'm going to make a claim, and you should be making a claim on the security deposit for failure to pay rent at a minimum. You need to do that essentially within 15 days of their departure to send a certified letter saying I'm collecting that $250 for failure to pay rent. So that's the easy part. If they do not answer within 15 days of receiving it, they have waived their right to that, and you're entitled to that money.
Well, I want to clarify, if Ann does not know where those tenants have moved to, Ann would have a right to send that certified letter to the very piece of property she owns and they moved out from. That's
very common, to send it to the last known address, which is often the address of the property.
All right, so Ann, the point about that is that if you want to keep that $250, it requires affirmative action on your part and write this letter by certified mail to them. So part number two is that these tenants have left stuff in Ann's house. What should she do?
Okay, this is the part of the question that's more difficult, and one of the reasons why it's a great idea to have a lawyer write your lease, because when I write leases, one of the things that I do in those leases, which you don't see in a FAR bar lease, is an extensive statement that basically says, if you leave and I can't find you, or if I evict you, or if you give the premises back, you give me the stuff that remains so that I can dispose of it. So it settles that problem. They've given you authority to dispose of this stuff. And the reason I do it is because how difficult it is to figure out what to do with stuff when there's no such provision. Florida statute has a very extensive and, in my opinion, almost useless part of the law that says you have to notify the sheriff and they have to have a sheriff's sale and all this stuff. That's never going to happen. So what I tell people to do in that case is to guard the, to store the property for a while. If it's under a certain amount, which I think is $500, you're allowed to dispose of it. But anything over that, you store it, and after a reasonable period of time, you dispose of it on the belief that it will not be, that the risks are worth taking at that point.
Well, to clarify with Ann, let's assume that her lease does not cover this language about personal property left behind. So the bottom line is that Ann is under a statutory obligation to give notice to these tenants of what her intention is to do with their stuff, whether it's to give it away or put it in storage or throw it away.
That's right. But the end product of that notification regime is that it ultimately gets sold by a sheriff. And the thought of a sheriff publicizing a sale for $750 worth of an old couch doesn't seem like a very likely result. So the better result, from my mind, is to do that notification, hold on to the property in the garage or someplace, and there'll just come a point where you'll know this is not going to be a subject that's going to come back and nip me later on.
Thank you, Rob.